Great. Thanks, Paul. And thank all of you for attending this and for at least bearing with me as a lawyer. I'm sure most of you are not thrilled to be interacting with me if you know me on a regular basis, because it often means there's an issue. But I'm going to try today to talk, and for those of you who don't know Sutherland, we are a large corporate law firm, of which you are all probably pretty familiar with the type, but what makes Sutherland unique is the fact that we have a specialized commodity trading practice. I personally work with between 30 and 40 commodity traders of energy commodities, primarily liquid, as Paul outlined. We don't represent NBB. We don't represent any trade organization. So, my words are my own, and those of my law firm. We do represent, however, a number of members of NBB and other trade organizations. And, I say that because it's relevant from the standpoint of we are not advocating a particular policy, so don't take whatever I say as saying he's really advocating for this point or this point. I'm really going to try to tell you what I've seen from my experience over the past 10 years of working in this area and lessons learned from the trenches in shipping crude, refined products by rail and by truck, and covering the full gamut of issues. A little bit of background. You all are probably extremely familiar with what is driving the movement of biodiesel throughout the U.S. And I'm not going to dwell on that. In fact, you have some great panels as part of this conference. Notice Paul Argyropoulos is speaking tomorrow. I will be very interested to hear what he has to say about the RFS. And I know there are panels later today about the LCFS. So I'm not going to dwell on that, but what I do want to mention is that regardless of what your view is on the RFS and what Trump and Scott Pruitt and the rest are going to do to it, I think you need to remember two things. One, it's a creation of legislation, so it's not going to go anywhere immediately. And two, the counter view by those environmentalists, those supporters of not just the RFS, but a wide range of climate change policies, is that Trump and Scott Pruitt are going to roll back a number of those policies. And there's going to be entrenchment by the states on their existing programs, in my opinion at least. This is what you saw why you have a number of these programs in the first place, is because of the Bush administration and states taking an active role. So a number of these policies, blend mandates for biodiesel blending are, some of them are active, particularly in New York City. Others are a little bit more nascent. I think you're going to see more robust action with those blend mandates and on the West Coast. I'm sure some of you are probably, hopefully most of you are aware of what's going on with the California Cap and Trade Program, the pending lawsuits against the Cap and Trade Program. Again, I'm not going to forecast on that. I would only say that regardless of what happens, you're going to have, I think, likely a real movement by those in the state to remedy if the courts do take some action to impact the Cap and Trade Program following oral argument, which I think is scheduled to be this week or early next week. So I see these programs being very key. In other words, you're going to have movement to the coasts of product from where it's largely produced in the middle of the country. I'm going to skip just ahead to the bottom left, the image on the bottom left, because I think it highlights, this is exactly what we've seen with crude by rail over the past 10 years. You have a lot in common with the crude industry. You had a industry 10 years ago where I had a client in 2008 who called and said, hey, I've got this potential investment. It's in this strategic play in North Dakota. Nobody's really heard of it. It's called the Bakken. And now everybody's heard of that. And the issue was how you're going to get crude from the Bakken out. They didn't have the pipeline infrastructure. It wasn't readily available. You had a lot of objections to it. You still have a lot of objections to it. Biodiesel industry doesn't have pipelines, so what are you going to do? You're going to rail and truck it. And I realize for those of you in the industry, those pictures are very scary. As a lawyer, I like to scare people. It's, it gets your attention. But it's, I think, the lesson I want you to take away from this presentation, we counseled a large number of primarily shippers, as I said, commodity traders, those that own the product, producers, the commodity arms of the producers of crude oil and refined products. None of them ended up facing direct liability during the whole crude by rail saga, despite these very scary pictures. But they have real potential liability, and particularly if there was an incident that either caused direct physical injury or actually resulted in fatalities. We were fortunate to not have that to date in the crude and refined products shipping industry, except in the case of Lac Mégantic, Quebec. For those of you familiar, there was an incident, I think 3 years back now, where product owned by a commodity trader, a large commodity trader, the brakes weren't set on rail cars at the top of a hill, or there was only one brake set. It let go and released and rolled into a town, killing more than 45 people. We never had that type of incident in the US, but in the case of the Canadian event, you still had liability faced by the shipper, who was a US entity, in the US based on lawsuits brought by both the railroad company who faced bankruptcy and two families of those who were deceased. They brought those lawsuits under negligence theories, under common law, tort theories of liability, as well as arguments that the shipper had not met their regulatory liability. So I say all that in that this is not something to be overly afraid of, to be scared of, hey, I don't want to enter into this industry or into this world at all, but to do so carefully, because you're not going to face the type of routine liability that you might in other areas. Instead, it is very significant liability exposure in the event of a catastrophic event, but there are ways to manage that, including saying, hey, I don't mind if my product's shipped by rail, but somebody else who has larger credit support, who has a more sophisticated line of business, is going to take some of those issues and run with them. So, what are some of the specific liabilities that you're looking at? So, in contrast to crude and refined products shipments, where those are fairly regulated shipments, and we'll talk about that in terms of if you are a shipper, if you're the product owner, what are the things you need to meet? Biodiesel doesn't really have that. It's not considered a hazardous substance. So that's, in and of itself, something that should give you some comfort. It's less regulated when it comes to shipping by rail and by truck than crude and refined products. Instead, your primary liability pathway is going to be through tort lawsuits, and those can, or from a regulator. And those are going to be a negligence-based standard, and I don't want to lose the non-lawyers in the room, but basically, as long as you meet your standard of the industry standard of care. So what everybody in this room is doing, so you guys talking about, hey, what are you guys doing when it comes to shipping by rail and by truck? If you're kind of following that and you're meeting also your regulatory obligations, whatever they may be, you're going to be largely covered. You can take a lot of comfort in that. But if you start talking to your colleagues and they say, or your colleagues at other companies, and they're saying, well, we're doing a lot more due diligence. We are taking a lot more steps when it comes to shipping documentation. We're doing a lot of testing. That's when your ears someone want to perk up and say, hey, okay, should I dig in a lot more on this? That's going to be your exposure pathway from suits by federal agencies, by third parties at the federal level. You also have state liability, and this is where my one real true recommendation would be is if you're looking at shipping by rail or by truck, take a look at where your product is going to be shipped through. So what jurisdictions is it going to go through, and what's the liability in those jurisdictions? In most states, you're not going to face much liability. The liability is going to be on the carriers, the actual railroads, the trucking companies. This is from the government standpoint. Because there's the one with custody over the product. But in a few states, and few key important states, California, New York, New Jersey, you face what's known as strict liability without regard to fault. So if there is a large-scale incident, you can be held liable for that incident simply because you own the product. Again, there are ways, and that in the case of some of those jurisdictions, that's more theoretical than actual liability, but it's possible. And again, you're going to want to manage that. And there are a variety of ways to manage that liability, but you should be aware of it. We've had a lot of clients over the years that have come to us after the fact and say, hey, turns out we've been railing refined products for years, and the legal department hasn't really looked at this. What should we do? And you got to go back and open up contracts and dig into your liability exposure. The last area where there's a sort of potential pathway for liability is what your role is with the rail car or the truck. If you're an owner or lessee of a rail car or truck, you can again potentially be held theoretically liable in the event of an incident. But there are ways of saying, okay, I'm not going to own the rail cars. I'm just going to have transportation service agreements. I'm going to have a lease, but it's going to be, I'm not going to give myself that much control over the maintenance, and somebody else is going to be responsible for that. Again, there are ways to manage that liability. You just want to be aware of it. You want to go in eyes open. Not the least of which is because you want to be sure you have the relevant, the requisite insurance and credit support. You also may have some obligations in the event of an incident, a minor spill, to notify a regulator, as well as the carrier, the railroad, also has that obligation, but you want to dot your I's and cross your T's. And you lastly want to make sure that your shipping documentation all lines up across the board. That shipper for Lac-Mégantic, Quebec, that horrific incident I talked about, where their liability sat was the fact they were saying, well, I'm shipping crude oil. And the plaintiffs in that case said, well, you're not really shipping crude oil. Your crude oil is a lot more similar to fuel oil. It's a lot more combustible than your standard crude oil, and has a totally different risk profile. And you would have handled, the carrier would have handled this differently, et cetera, et cetera. And so similarly with your products, are you shipping B100, are you shipping B99 or B80 and so on and so forth? Or does your product, which might have a unique production method, does that result in a product that maybe is slightly more volatile? Or is the feedstock result in a product that is slightly more volatile? I'm not saying I believe in any of those things, but those are the questions that a plaintiff's attorney will be asking and looking at. So you just want to ask those questions in advance and make sure that you're consistently labeling across the board to protect yourself, and you have the requisite SDS sheets, the safety data sheets, and you're meeting EPA's PTD requirements, et cetera. I don't want to dwell on this because I do want to leave plenty of time for my fellow panelists. I've already hit the fact that you as a biodiesel shipper are not going, if you're shipping pure B100, are not going to be considered a hazardous material. It's not volatile enough. However, diesel fuel is. So if you've B99'd your product, or you have some degree of diesel fuel in it, you potentially do have this other liability regime that comes in that you're going to want to meet. And that liability regime, again, isn't overly burdensome. You just want to be aware of it. And you want to manage it, and you want to build it into your compliance regime. And that's really making sure that you're using reputable carriers, rail companies, trucking companies, that they have a good compliance history, and that they're meeting the placarding, labeling requirements, that you have a safety and security plan in place, and that depending on the product you're shipping, if you're shipping something with diesel fuel in it, you are registered with the Department of Transportation. We have had, and I should say, all of this work is not a tremendous amount of work by outside attorneys. I mean, this is, or consultants. This is something that spend a relatively few amount of hours on helping clients get set up. It's a much bigger issue when we have had clients that have come to us and say, I have this inquiry from DOT. They asked about my crude trucking operation, and I haven't been registered and I've been doing this for 5 years. Kind of unwinding that, that's when you start incurring a lot more legal fees, even if you end up having no enforcement against you. It's just a much bigger hassle, and much, you have a track record at that point. So again, it's able to be managed. I want to touch on something, and Paul asked that I speak on this. It's saying, okay, why don't I just ship by vessel? And others can talk on sort of the logistical side of things. But the reason you all are not able to use vessels to ship your product is this thing called the Jones Act. It requires you to use a U.S. flagged vessel when shipping from one port in the U.S. to another. And it's not just ports, it's from one dock to another dock in the U.S. Even if your product, your customer cancels and the vessel has left the dock and you just want to bring it over to that other dock that's 100 yards away, that's a Jones Act violation. And it's a major issue that luckily you all largely don't have to be involved in, because there are no vessels right now. There are no U.S. flagged vessels that are carrying biodiesel B100, at least to my knowledge. If I'm wrong on that, please let me know. All the U.S. flag tankers capable of carrying liquid energy products are being used in gasoline and diesel and crude service, and are booked up on long-term charters. There's a relatively few amount out there. Some are aging out. There have been a resurgence of them. They're more and more available. But it would take a large number of vessels to be made available, at least to my knowledge, for the economics to work, where you'd be able to load a cargo of B100 and ship it from the Gulf up to the Northeast. Of course, that's all economically driven. Things could go, it could be economically incentivized enough for you to make it happen. But it's extremely expensive to get a U.S. flag vessel, because that's a vessel that needs to be built, crewed, and owned by U.S. citizens and built in the United States. Our labor costs, everything else, make it extremely expensive to do. It also makes it mean that, because this is a law that provides for a massive amount of U.S. jobs in both red and blue states, it's a law that's not going away even under the Trump administration. This is something that enjoys widespread support by labor in the U.S. And so as a result, you can't use a U.S. flag vessel. There are U.S. barges. You're probably thinking, well, there are waterborne movements, and those can happen, but those are largely coastal movements in the Northeast. Through articulated barge movements, you can get a little bit out into somewhat open water, but this isn't an ocean-going, large-scale vessel that's going to bring product from the Gulf up to the Northeast or through the Panama Canal or anything like that. Lastly, on this topic, the potential for waivers. You may be thinking, well, maybe Trump might waive the Jones Act for particular movements. And I think you're right. There could be the potential for that, increased potential, as opposed to under the Obama administration. We at Sutherland obtained the last waiver of the Jones Act in 2012, and that was during Hurricane Sandy. It's incredibly rare that these waivers are issued, and it's only in times of war or hurricanes or some type of natural disaster. However, I think Trump, through his appointment of Carl Icahn as a special advisor, through other indications, might be more open to providing a waiver for shipments of petroleum products to serve maybe some of the mid-Atlantic refineries from the Gulf. It would seem, a bit of a jump to have a waiver for shipments of biodiesel while excluding other types of liquid energy products. So I think you're really going to be looking to what my fellow co-panelists are going to be talking about of rail and truck as the means to get your product to the coasts. So I won't dwell on these conclusions, but I would say that, as a lawyer, when I speak at conferences, people can really often walk away scared, afraid of, the parade of horribles that have been rolled out. But I really want to stress that these are they're real risks. You should be aware of them, but you can manage them on a routine basis. Our clients manage them. They have managed them successfully to date. And just make sure you do it in advance. Understand what your liability is in all jurisdictions that you're shipping through. Build it into your compliance plans, and take that into account in how you allocate risk in your contractual documents and have the requisite insurance. With that, I will conclude my remarks. Thank you.